Hello, and welcome to the ULV Justice Center discovery stage of a civil litigation. Glad to have you. First, I want to let you know that the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you consult with an attorney. Discovery stage. In this section, I will be talking about discovery in general, the discovery plan, and also discovery tools that are available to you. Discovery in general. Overview. The basic purpose of discovery is to allow the parties to obtain the evidence necessary to evaluate their case, possibly reaching a resolution or settlement before trial, or in the alternative, to present their best possible case and their best defense at trial without any surprises. Through discovery, you can identify the facts, evidence, and witnesses which help strengthen or weaken their case. This information will help you initially formulate and alter your approach, strategy, and tactics. Discovery also serves to identify additional witnesses or a third party that needs to be joined in the lawsuit by joinder. A joinder simply means the bringing together of different parties into one lawsuit. Discovery also serves to narrow and clarify the issues in dispute, preserve testimony and evidence for trial, promote early settlements. This way you can avoid a lengthy and expensive trial. And finally, it could prepare parties for trial and eliminate surprises. Discovery plan. Overview. Developing a discovery plan is essential and can act as a roadmap for where you are and where you want to go, in terms of what you need to prove, what do you want to obtain from the other side, and how you want to obtain it. Three important questions that you must always consider when drafting your discovery plan are: number 1, what do I have? Number 2, what do I need? And number 3, how do I get it? A good discovery plan serves several purposes: obtaining proof of your claims or defenses, pinning down your opponent at an early stage, selecting the proper discovery tools to obtain the information needed, to prepare a blueprint for the entire discovery process, and the blueprint will ensure that you always have a goal in mind when you serve discovery, choose the best discovery method to accomplish your goal, and coordinate discovery tools to maximize the effectiveness of your discovery. And lastly, the timing of your discovery so that you have what you need at various stages in litigation. As far as strategy goes, your discovery plan should allow you to seek documents as early as possible so that they are not lost or destroyed, move from broad information to more specific information in requests, consider the advantages of each discovery tool, and coordinate different discovery tools to work together. For example, interrogatories and inspection demands may be coordinated so that all documents identified in the interrogatories are demanded. Depositions may be coordinated with document demands so that the deponent is questioned about the documents at the deposition. And requests for admissions may be coordinated with interrogatories so that interrogatories seek all facts upon which denials are based. Keep in mind there is no single way to create a discovery plan. It's just a matter of personal style, and it may vary depending on the type of case you are dealing with. Discovery tools. These are the different types of ways that you can obtain information from the other side. First, we will discuss interrogatories. There are two types of interrogatories: form interrogatories and special interrogatories. Form interrogatories is a judicial counsel form DISC-001. It is a list of already prepared standard questions relating mostly to insurance. They are typically used in personal injury and wrongful death lawsuits. Special interrogatories are written questions to the other party who responds in writing under oath. The advantages to interrogatories is that they are inexpensive. They have a potential for disclosing a lot of information because the responding party must provide all information within the knowledge of the respondent and all information available to him or her. Interrogatories are one of the few methods of determining the legal conflict and opinion of the respondent. Some disadvantages are that they frequently result in objections to avoid answering. They allow for an artful drafting of responses to avoid providing any real information, and not available for obtaining information from non-party witnesses. Drafting requests and responses of interrogatories. To prepare form interrogatories, you only need to complete the caption portion of the form and check off the questions that you want answers to. Special interrogatories are done on pleading paper. You type the questions that you want answers to, making sure that you ask very specific questions, straightforward and to the point. If used correctly, interrogatories require the opposing party to disclose the theories upon which their allegations are based, state the facts upon which those allegations are based, identify the name and address of the people with knowledge of the facts upon which those allegations are based, and describe the documents that support the allegations. Drafting responses. A party may respond to interrogatories one of the following ways: seek a protective order for permission not to answer, do nothing, which waives all the rights to object, or respond by answering and/or raising objections. One may object to an interrogatory on the ground that it calls for privileged information, asking for information of communications between you and your attorney. It exceeds the scope of discovery, seeks information not relevant to the subject matter, seeks information about the contents of documents. The interrogatory may only ask for the identity and location of documents, so you're not required to comment on the document's contents. Burdensome and oppressive. It requires effort on your part so great to be unjust. Violates format requirements. Not allowed compound questions or subparts, so you are not required to respond to those. It exceeds 35 without attaching a declaration for additional discovery. Any additional questions beyond 35 do not need to be answered. Additional information. The plaintiff must wait 10 days after the defendant is served with the complaint, and the defendant may start discovery as soon as it is served with the complaint. You have 30 days to respond, unless you have coordinated with the other side and made arrangements for additional time. Failure to respond timely waives all rights to object to the interrogatories or claim privileges, including work product and attorney-client privileges. Service. Interrogatories must be signed. Copies of interrogatories must be served with a proof of service. You keep the original copy, and responses must be verified and served with the proof of service to the propounding party. Failure to respond on time waives all rights to object to the interrogatories or claim privileges. Another discovery tool that you have available to you is called an inspection of documents, things, and places. An inspection demand is a written request and may only be served on a party. A party may demand the right to inspect, copy, test, or sample documents or other physical evidence or electronically stored information in possession or custody of the opposing party. The only advantage to this tool is that it is a least expensive way of obtaining documents or records from an opposing party. However, for electronically stored information, it can be very expensive. The only disadvantage is that it is ineffectual where records or evidence held by non-party witnesses. Drafting requests and responses. In your requests, you must specifically describe individual items or particular categories of items. The description must enable the responding party to know what to produce. Avoid overbroad questions. If you must make a very broad document request, follow it with specifics as to why. And if you are demanding electronically stored information, Be sure to specify the format you would want it in. Responses. The responding party must respond in 2 steps. Prepare and serve a written response, and produce the documents or things requested. For each request, the written response must state one of the following. A, the party agrees to comply. B, the party is unable to comply and why. Or C, the party objects to the request and why. Agreeing to comply with a demand requires a statement to the effect that the production, inspection, and related activity demanded will be allowed either in whole or part, and that all documents or things demanded are in possession, custody, or control of that party. Stating the inability to comply with a demand requires a statement to the effect that a diligent search and reasonable inquiry has been made in an effort to comply with the demand. And further, you must specify why you cannot comply. Is it because the particular item has never existed? Has it been destroyed? Has it been lost or misplaced? Stolen? Has never been or is no longer in the custody, possession, or control of the responding party? It must also include the name, address of anyone that is known to be in possession or control of that item. Objecting to a demand. The response must identify the particular item or document you are objecting to and clearly state the reason for the objection. You can object to part of a request, but must answer the unobjectionable portion. If you object to the form for producing electronic discovery, you must specify why. Additional important information. Plaintiff must wait 10 days after the defendant is served with the complaint or 10 days after the defendant appears in the action, whichever occurs first, before propounding on the other side. You can challenge the responses to the inspection demand by filing a motion to compel further responses to a demand for inspection and for monetary sanctions. Service for inspections of documents, things, and places. The inspection demand must be signed. The copies must be verified and served with a proof of service. It is not filed in court, and you keep the original copy. Failure to serve the written responses on time waives all rights to object to the inspection demand or claim privileges, and everything must be produced. Another discovery tool that you have available for you is a request for admissions. Requests for admissions are written requests on pleading paper that asks the other party to admit or deny the truth of each listed statement of fact, opinion related to fact, or application of law to fact, or to admit or deny the genuineness of the documents attached to the request. Some advantages for a request for admissions are that the requests are inexpensive to prepare, they're absolute and binding. They can help determine what facts the opponent will admit or challenge at trial. They force the opponent to take a good look at their own case to determine whether they have all the evidence required to win. The responses are made under oath or verified and may be used against the other party at trial or during litigation. The court may impose terminating sanctions for evasive responses, and requests may be followed by form interrogatories 17.1 seeking the facts supporting responses if they are denied. The disadvantages for requests for admissions are that they are limited to 35, so you must be very specific and clear. The responding party may use their response as a stalling tactic, and they typically involve less important issues, as the important issues in the case will have to be proven at trial. Drafting requests and responses. Be sure to specifically state that the party must respond to the request within 30 days, or the request may be deemed admitted. Each request must be clear, precise, short, independent, and complete sentence. Be sure that there is only one fact to be admitted or denied in each request. Look over each request to make sure that it will contribute to the case in general, and don't waste any of the limited number of requests. To obtain an admission that a document is genuine, you must completely describe the document and responses. Respond to each request separately and number each response consecutively to correspond with the requested answers. Each answer must do one of the following: admit any part of the request that is true, deny any part of the request that is untrue, specify any part of the request about which you lack sufficient information or knowledge to respond, or they can object to the request. Denials must be based on good faith, state the specific ground for any objection or claim or privilege. You may seek a protective order to avoid responding. Unverified responses are no responses. And any additional important information, challenging the responses. Upon receipt of the responses, they must be reviewed to determine if the responses are incomplete or if the objections are without merit or too general. If they are believed to be improper, you can consider a motion to compel further responses. But before you do so, you are required to meet and confer with the other side to try and resolve the dispute. Either party failing to meet and confer will be sanctioned. Notice of the motion to compel further answers must be given within 45 days after the service of verified responses. If not, then the right to do so is waived. You can challenge the responses to the inspection demand by filing a motion to compel further responses to a demand for inspection and for monetary sanctions. Service. Inspection demand must be signed. Copies must be verified and served with a proof of service. They are not filed in court, and you keep the original copy. Failure to serve the written responses on time waives all rights to object to the inspection demand or claim privileges. Everything must be produced. Depositions. A deposition is an exam of a witness under oath with opportunity for cross-examination. The advantages to depositions are anyone, even people and entities who are not parties to the lawsuit, may be deposed. Depositions may be used to discover information in the form of testimony and production of documents or tangible things. Depositions are the only method to obtain spontaneous testimony and to ask immediate follow-up questions. Depositions are the only method which allows the attorney to assess whether or not the deponent will make a good trial witness. Depositions can require the deponent to commit him or herself to a particular story, and in detail. Later inconsistent testimony may be introduced at trial to discredit the witness. Deposition questions may ask about the content of documents, not just their location and identity. Depositions preserve testimony and, when noticed properly, may be used at trial if the defendant is unavailable. Settlement may be encouraged if the deponent is intimidated by all the questioning at the deposition. Some disadvantages of depositions are that they are very expensive and time-consuming. The witness may only be asked for their personal knowledge and current memory. Depositions can educate the opposite side, allowing them to strengthen their side of the case. Types of depositions. An oral testimony of a party. This is a party being deposed. The last discovery tool that we will go over is a demand for physical examination. Whenever the physical or mental condition of a party is in question, the other party may, on showing of good cause, seek a court order for the exam. There is an exception. In personal injury cases, the defendant may demand a medical exam of plaintiff without leave of the court or showing good cause. The advantages for independent medical exams, or IMEs, are that they are the only way to obtain first-hand evaluation of the plaintiff's condition. Otherwise, the defendant has only the testimony of the plaintiff's treating physicians, and the plaintiff's experts' opinions to evaluate the plaintiff's condition. Also, sometimes just the threat of an IME might encourage settlement for a plaintiff. Some disadvantages are that they can be extremely expensive, and the IME report, which is available to the plaintiff, might support the plaintiff's claim of injury. Drafting requests and responses. A request for a demand for an IME is made in writing and done on pleading paper. A defendant may serve the demand immediately after they are served with the summons and complaint. The demand must be served 30 days prior to the date of the examination. Responses. A written response to the demand must be served within 20 days after the service of demand. This response must indicate that the examinee will do one of the following: comply with the demand as stated, comply with the demand as specifically modified by the examinee, or refuse for reasons specified in the response. Additional information on IMEs. The exam is like any other medical exam. The doctor will ask the patient for medical history and then conduct the exam. The plaintiff's counsel or paralegal may attend the exam for the purpose of recording of the spoken words to or by the examinee, or observing the examination to ensure that it is within the scope of the demand and that no unauthorized diagnostic tests are being taken. Mental examinations require a court order as they are considered to be an invasion of privacy. Service. Defendant serves a copy of the demand with a proof of service on all parties who have appeared in the action. The defendant keeps the original copy. Failure to respond or comply will result in sanctions, and the sanction is at the discretion of the court. That completes the discovery stage. Just as a reminder, throughout the page you will see words that are highlighted in light blue color. Those are links to documents. Please feel free to use them. And some of the documents are actually templates that you can use. Just remember to edit them so all relevant information pertaining to your case is in there. Thank you for visiting the ULV Justice Center. Next, you will be learning about motions.